Welcome to the Mud Puddle Theory. Hi, I'm Jerry and Quick, and I wrote the Mud Puddle Theory with the goal of uniting and bringing us closer together as a nation for the truth concerning our dark past history and how it is being used to divide us as a nation. In order to know and understand the underlying causes for our division, you must know the truth concerning our dark past history and how, over the years, it has been misrepresented, changed, and even lied about to deceive, manipulate, coerce, convince, and even brainwash us into believing that something is true when it is not true. In other words, propaganda. In my last video, the Civil War, I had talked about how the 13th Amendment had abolished slavery and involuntary servitude, and how an estimated 6 million black slaves were freed and an estimated 600,000 white slaves were freed. Approximately 46 years after the 13th Amendment was ratified and made a part of the U.S. Constitution, Congress then passed the White Slavery Act of 1910. If you've never heard of the White Slavery Act of 1910, I'll explain it to you, what it was and the purpose of passing the law at the end of this video. This only reinforces my prior statement that slavery is not, nor has it ever been, about race. In my prior video, I did briefly mention the 14th Amendment, stating that the 14th Amendment did make the freed slaves citizens. However, the 14th Amendment did much more than just made the freed slaves citizens. The 14th Amendment brought about a lot of controversies that are still being litigated through the courts today. While I may touch upon some of those controversies, there are far too many for me to cover in this video, and are controversies which I may not have covered or even mentioned in the Mud Puddle Theory. The 14th Amendment opened Pandora's box and has not only created controversies that we are having to deal with today, but will more than likely create other controversies that will be with us for years to come. As I stated in my prior video, the Civil War, prior to the presidential election of 1864, Abraham Lincoln chose as his running mate for Vice President Andrew Johnson, who was a Democrat from Tennessee. When Abraham Lincoln was assassinated, Johnson became the president, as is provided in the U.S. Constitution. Even though 11 of the southern states were not represented in Congress at that time, Johnson was able to take the required number of talk the required number of southern states into ratifying the 13th Amendment and make it part of the U.S. Constitution. Since the slaves had been freed by the 13th Amendment, the next step was to make the freed slaves citizens and to give them the same rights and privileges given to other citizens. Even though the 14th Amendment was strongly debated in Congress, Congress finally got enough votes to pass the 14th Amendment, and it then went to President Johnson for his signature. Johnson vetoed the 14th Amendment, stating that he would not sign the amendment because 11 of the 36 states were not being represented in Congress, and that he would not sign it until those 11 states were admitted back into Congress so that they could be a part of making the law. He also said that the 14th Amendment discriminated against whites. Congress then passed the 14th Amendment over Johnson's veto, which later led to Johnson's impeachment. The last step needed to have the 14th Amendment made a part of the U.S. Constitution was to have it ratified by the states, where it met a lot of that opposition in the South, especially in those southern states who were not being represented in Congress. After failed attempts to have the 14th Amendment ratified, Congress passed the Reconstruction Acts of 1867 and 1868, some of which I mentioned in my last video on the Civil War. One of the conditions of the Reconstruction Acts was that the southern states had to ratify the 14th Amendment before they could get their seats back in Congress. The southern states who were not represented in Congress when the 14th Amendment was passed and would not ratify the 14th Amendment finally gave in and ratified the 14th Amendment and were given their seats back in Congress. The 14th Amendment was ratified and became part of the U.S. Constitution on July 9, 1868, even though it is still being debated today whether or not it met the requirements of the U.S. Constitution. The main section that concerns the freed slaves becoming citizens, and the section which has been a major focus of litigation to determine its meaning, is Section 1, which is as follows. Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Of course, a major controversy isn't about whether the freed slaves were citizens under the 14th Amendment, but under what circumstances would someone coming into the United States affect the citizenship of a child born during the time that they are here. In the Civil Rights Act of 1866, in defining citizenship, it did exclude Native Americans who lived on reservations and were not subject to the jurisdiction of the United States. Later, Congress did pass an act for Native Americans who had left the reservations to become citizens. In 1866, when the 14th Amendment was being debated, immigration, and especially illegal immigration, was not discussed, so that was not covered in the 14th Amendment. The only case where the U.S. Supreme Court addressed that issue is where a Chinese couple were living here as permanent residents, running a business, and had children. The court ruled that since they were here legally, that their children were citizens under the 14th Amendment, indicating that their children were citizens because their parents were here legally. The prevailing view today is that any children born of illegal immigrants who are in this country illegally are citizens under the 14th Amendment. President Trump got a lot of criticisms when he made the statement that they were not citizens. To the best of my knowledge, the U.S. Supreme Court has never addressed that issue. However, as I previously stated, the U.S. Supreme Court did, in my opinion, previously ruled that children born to parents who are legally in this country are citizens. If the U.S. Supreme Court follows its precedents, the children born to illegal immigrants who are in this country illegally would not be citizens. Recently, it was reported by the news media that President Trump was going to sign an executive order that would clarify that issue and would state that any children born people in the U.S. illegally would not become citizens under the 14th Amendment. There is no doubt in my mind that there will be some serious opposition to his executive order, which should force the U.S. Supreme Court to review the executive order and lead to a decision concerning the citizenship of children born to illegal immigrants in the United States. Since Kavanaugh was confirmed and now sitting on the U.S. Supreme Court, there are now 5 conservatives sitting on the court, and there's a very good chance that the executive order will be ruled as constitutional. I agree with President Trump's statement when he questioned whether or not children of illegal immigrants were citizens, and I look forward to the U.S. Supreme Court's ruling concerning this issue because, as I stated earlier, there's already been a case that sets the precedence that before children of immigrants born in the U.S. can be citizens, the parents must be here legally. Personally, I don't see any way that the court's ruling can be otherwise, but we will have to wait and see. Should the U.S. Supreme Court rule that children of illegal immigrants born in the U.S. are not citizens, It will create a lot of chaos to determine who is and who is not a citizen. From a humanitarian standpoint, hopefully, the government will provide a way for some of them to become U.S. citizens. It should pave the way to do away with sanctuary cities, prevent them from voting in our elections, deter them from crossing our borders, and reduce the welfare benefits that are being provided to the illegal immigrants that are currently in the U.S. One of the first issues to be litigated under the 14th Amendment was concerning segregation of the schools under the Equal Protection Clause. In Plessy v. Ferguson, 1896, the U.S. Supreme Court held that states could impose segregation so long as they provided similar facilities. It's been known as the separate but equal doctrine. Plessy v. Ferguson was later overturned in Brown v. Board of Education, 1954. Even though there were attempts to get around the court's ruling in Brown, schools and colleges remain integrated today. Immediately after the Civil War, the freed black slaves were having problems exercising their right to vote, so Congress passed the 15th Amendment, which was ratified by the states and became law on February the 3rd, 1870, to clarify the blacks and or freed slaves' right to vote. After Reconstruction ended in 1877 and after the whites' right to vote was reinstated, most of the southern states began to pass the black codes, Jim Crow, and as part of the laws, they passed laws creating the poll taxes, which had to be paid before anyone could vote, and the literacy test, which required a person to pass before they could vote, both of which were probably intended to keep the blacks from voting. The U.S. Supreme Court rejected the blacks' argument that the laws discriminated against the blacks and denied them their right to vote. The court basically held that it did not only affect blacks, but it affected all poor people who were poor and could not pay the tax and who were also uneducated and could not pass a literacy test, which included the poor whites. The Voting Rights Act of 1965 did away with the poll tax and literacy test created by the black codes, Jim Crow. My biggest concern with the 14th Amendment is how it has and is still affecting states' rights as is guaranteed by the 10th Amendment, something which was agreed upon during the Constitutional Convention to preserve the individual states their right to self-rule. Section 1 does require the states to guarantee to their citizens the rights that are provided under the Bill of Rights, which is a part of the U.S. Constitution. As a lawyer, when I did have a case that involved a suppression issue, such as a search and seizure, illegal stop, illegal warrant, illegal confession, etc., I would usually include in my motion to suppress the following as it applies to the states under the 14th Amendment to the U.S. Constitution. However, most states have adopted the Bill of Rights in their state constitutions. As part of my preparation to file a motion, I always look at Alabama's Constitution because I have learned through the years that our state's Constitution may actually provide more rights and privileges than the 14th Amendment. While I am concerned about other states' rights issues under the 14th Amendment, of most concern is the U.S. Supreme Court's decision on abortion in Roe v. Wade in 1973 and their decision in Jailfeld v. Hodges 2015 concerning same-sex marriage, both of which are states' rights issues. I was very interested concerning the confirmation of Brett Kavanaugh as a Supreme Court justice because he is a conservative. While the circus on TV was about the alleged sexual assault when he was a teenager, the underlying battle to keep him from being appointed was really about a woman's right to abortion and the LGBT's concern that the court's ruling on same-sex marriage would be overturned. Both cases were decided by a very close margin and are subject to being overturned. There are now 5 conservatives on the court, so I do look for both cases to be overturned on the state's right issue. It will be very interesting to not only see if these cases will be overturned, but it will be just as interesting to see how the court rules on whether or not children of illegal immigrants born in the United States are U.S. citizens. At the beginning of this video, I had mentioned the White Slavery Act of 1910 and promised you that I would briefly discuss that act and give you an explanation of what it covered. I was retained to represent a man who had been initially arrested for recruiting young women to go to Las Vegas, Nevada for the purpose of prostitution. And when it became apparent that Alabama did not have any laws that he could be prosecuted under, they turned to the U.S. Attorney to see if federal charges could be brought. After some manipulation, they finally decided to charge him under the White Slavery Act of 1910. Under that act, the feds could assist the states in enforcing their state law. Of course, this case involved prostitution, and at the time, Nevada did not have any laws prohibiting prostitution. Nevada left it up to each county to decide whether to pass laws prohibiting prostitution or allowing prostitution. There was no law in existence at the time that they could prosecute black lives under. Thanks so much for watching. I hope that you have learned something from this video that will help you understand the importance of us uniting and coming together as a nation. Please like, subscribe, and feel free to share this video. I not only welcome, but I encourage you to leave meaningful and productive comments below. Please, no cursing, profanity, or name calling. Feel free to correct me and tell me that I am wrong, and furnish me with any authorities that will support your comment. Thanks again for watching. God bless America.